And welcome to the Scaringi Law Lunch Break. This is your time of the day to learn a little bit about the law while you enjoy your lunch. Today's topic: abuse victims are creditors in Roman Catholic Diocese of Harrisburg's bankruptcy filing. You probably all know by now the Roman Catholic Diocese of Harrisburg filed for bankruptcy under Chapter 11 of the United States Bankruptcy Code on Wednesday, February 20th, to the great alarm of the community and particularly victims of sexual abuse. Scaringi law attorney Kelly Walsh was asked to appear on CBS 21 News to offer some guidance to the viewers who want to know what this means, particularly to those members of the community who could be affected by the bankruptcy. The first thing to know is that there is an automatic stay that goes into effect with bankruptcy, so no new lawsuits can be filed against the Roman Catholic Diocese of Harrisburg at this time, and any pending lawsuits must come to a halt due to the bankruptcy filing. That does not mean victims should do nothing, though. Quite the contrary. Victims of abuse who could have claims against the Roman Catholic Diocese of Harrisburg are now creditors in a bankruptcy. Creditors who hope to be paid in a bankruptcy must file a proof of claim, which is a legal filing asserting their right to receive some sort of monetary payment. If a creditor has a claim that arose before the bankruptcy was filed, knows about the bankruptcy but fails to come forward in time to file a claim, that creditor is forever barred from asserting their claim. And that is especially important in a case like this, where there are likely victims of childhood sexual abuse who have not yet come forward. Many victims are likely still struggling to process and come to terms with the traumatic offense in their past. The challenge they face to come forward is daunting, highly emotional, and personally difficult. Now is the time to do that, though. This bankruptcy filing puts a mandate on those victims. They are now creditors in a bankruptcy. If they don't come forward to assert their claim now, they may never be able to do so in the future. There are certain types of debts that are not discharged in a bankruptcy. If a debt is not discharged, that means the debtor must still pay it. For example, most tax debts and domestic support obligations are not discharged. Criminal fines or penalties in an order of restitution issued under federal criminal law are not dischargeable in bankruptcy. But the claims for civil damages individual victims may have are a lot less certain. There is potential to have those claims determined to be non-dischargeable, meaning the creditor, in this case the Diocese of Harrisburg, still must pay them in the bankruptcy if the court determines the claim arose out of a willful and malicious injury by the debtor. And I describe the Roman Catholic Church as the creditor, but I mean the debtor. So if the claimant can prove that the claim arose out of a willful and malicious injury by the debtor, the Roman Catholic Diocese of Harrisburg, then the claim may be able to proceed through the bankruptcy court, and if the claimant is victorious in the pursuing the underlying claim, then the church would have to pay whatever monetary award is handed down by a court, and it would not be dischargeable. So that's kind of the story there. Now, pursuing a claim in bankruptcy court is not automatic. The victim must file a proof of claim and then must proceed with further filings to request a determination that the claim is non-dischargeable so they could proceed and continue against the church. If the victim fails to come forward in the bankruptcy, their claim will be discharged, even if it was resulting from a willful and malicious injury. So if you have a claim, you must assert it. It's not going to be automatically conferred upon you. You've got to hire a bankruptcy attorney and get in a bankruptcy court. If you have a claim against the Roman Catholic Diocese of Harrisburg or any other bankruptcy debtor, you should talk to an experienced bankruptcy attorney right away. And you can call Scaringi Law at 717-657-7770 to schedule a free consultation. We can help protect your claim as a creditor in bankruptcy. We have bankruptcy attorneys here, one of whom sits on the board of the Bankruptcy Bar Association here in the Middle District. Well, that's about all the time we have today for the Scaringi Law Lunch Break. I hope you learned a little bit about the law. Thanks for listening and enjoy your lunch.